MILIND. And now request our director, madam, to please welcome the gathering.
Dr. MILIND SATHE, my colleagues and students at DMHSL School of Law, and my colleagues and students at Nari Gursani Law College, for whom this program is online. Professor Balani, our Registrar SATHE, a very good morning and a very warm and a hearty welcome to each and every one of you. Teaching is a very satisfying and enriching profession. And where the student excels in his area of knowledge and practice, the teacher's joy knows no bounds, because the teacher herself feels fulfilled. And this feeling of fulfillment is something very unique. It cannot be explained or described. It is to be felt and experienced. This morning, when I stand before you and I welcome Dr. MILIND SATHE, I am filled with those same emotions, because he was my PhD student and scholar, and he has distinguished himself and made a mark not only in legal circles, but also in the society. Despite all this, whenever I've asked him for my Guru Dakshina, and more than once, earlier for Nari Gursani Law College students, and now for DMHSL School of Law, and of course, my Guru Dakshina is not like asking Eklavya or anything. I want him to interact and enrich my students, because we have kept him on a pedestal. He has very willingly obliged to do that. So on behalf of HSNC University and DMHSL School of Law and HSNC Board and Nari Gursani Law College students, I extend a very warm welcome to Dr. MILIND SATHE.
Madam, may I also request you to please felicitate our guest speaker. Now invite Assistant Professor Krishna Kamath Keskar to please introduce our guest speaker.
A very good morning to all of you. A very good morning to the dignitaries and esteemed guest speaker. It is rightly said that a one-to-one conversation with a wise man is always better than 10 years of study of mere books. And yes, this is the opportunity for all of us today to accumulate the knowledge of more than 10 years from our esteemed guest speaker. Sir, your work is so extensive that it's impossible for me to concise it in few minutes. But to just have a bird's eye view for all of us, Dr. Sathe's career in law started as a first-class master's degree, the LLM course that we call. Yes, then he went on to further pursue various diploma courses in many fields, not only law, but fields like journalism, social service, business management, so on and so forth. He also holds a PhD from Mumbai University. A very unique thing to note about him is that he did not only gather knowledge, but he strongly believes in imparting knowledge, for which he was a professor at Government Law College between 1987 and 1992, where he extensively taught constitutional law. Even today, he is a regular visiting faculty at Bar Council Lecture Series, Government Law College, KC College, ISC Law College, Pune, many such colleges, the list is never ending. He also holds workshops. He holds workshop for Bar Council of India and Maharashtra on writ petitions, company law, and various suits. Dr. Sathe joined the bar back in 1982, okay, where he chambered with former Justice D.R. Dhanuka, former Justice of High Court. Dr. Sathe is practicing in High Court as well as in Honorable Supreme Court. He has practiced and appeared in various matters where there was 5-judge bench, 7-judge bench, and also 9-judge bench. He has practiced a number of cases where there was a question of constitutional validity of Public Premises Act, constitutional validity of the MHADA Act, constitutional validity of the Rent Act, just to name a few. He has also appeared before the 9-judge bench where there was a question raised. And the question was a very severe question, a very sensitive question, because it pertained to the 39th Amendment of the Constitution. Our guest speaker was the one who appeared before a 9-judge bench in this matter. He has several public interest litigations. He has also legal service matter in his names, and he has also been appointed as amicus curiae by the court in various matters. He is a senior counsel for State of Maharashtra Municipal Corporation of Greater Mumbai and other corporations and public sector units. He was an honorary secretary for High Court Law Library from 1986 to 1990, and he was also an honorary secretary of Bombay Bar Association from 1996 to 1999. He was a former president of Bombay Bar Association from 2014 to 2021. Sir, may I please request you to please address the gathering here as we all are waiting eager to plunge in the ocean of knowledge.
I think the system is connected there, perhaps.
Yes, everything is connected.
This is fine.
Yeah, because you.
Dr. Chandiramani, my teacher, director of this institute, Professor Balani, and my young student friends. It has always been a pleasure to be back to the law college, and I always look forward to going to law colleges, talk to the students, interact with them, and gain from their questions and their experience, because a professor learns with interaction from law students. I must tell you one experience of me in the government law college. Those were the days, 87 to 90. They were the formative days of Supreme Court's public interest jurisdiction. And I used to tell students to bring newspaper. And from the front page, find out a news item which has a constitutional relevance. So the students would be enthusiastic to find out a news item we would discuss that news item and the underlying constitutional issues relating to that news item. Of course, today you will find 5 of them on the front page in newspapers, because the courts are virtually in every aspect of the country, in the governance, legislation, or administration, everything. So, but in those days, it was something rare, and that's what we used to do. So I used to learn from my students, and that's always a good experience. This morning, I'm going to talk to you, and then we'll have a discussion on the aspect of personal liberty. Personal liberty is something which is as old, as traditional as the humanity. But we are not discussing that. We are discussing the legislations, the enacted laws, or recorded history insofar as personal liberty is concerned. The first document which was enacted, written, signed, which recorded personal liberty of human beings as a right was Magna Carta in 1215. It was forced upon the king, barons, and the archbishop. There were disputes between barons and king, and archbishop mediated, and he made king sign Magna Carta, which recognized 2 rights: personal liberty and liberty from those days right up to the American Constitution, included that your life, liberty, and property will not be forcibly taken except by enacted law, by due process of law. Of course, many people may not know that Magna Carta signed in 1215 was repealed in 1225. So it lasted only 15 years, but it was the seed of enactment of personal liberty. And that continued. The next important document on personal liberty was in 1776, the 4th July, the Independence Day of United States, the American Declaration of Independence, and it declared all men are born free and they are all equal. That's the first declaration in a democratic constitution of United States. Then came the American Constitution in 1787. Significantly, that constitution did not recognize personal liberty as a right of the citizens. That came by way of a 5th Amendment. So you must have seen in all American serials and the programs, like, for example, Suits or LA Law, etc. I will take 5th. 5th is that 5th Amendment, which guarantees all these rights. And that's a Bill of Rights introduced in American Constitution. And the Bill of Rights, that 5th Amendment, had all the 3 things. One was right to property, one was right to life, and one was right to liberty. And it proclaimed and declared, no person will be deprived of his life, liberty, and property without due process of law. Now, that was the great significant assertion by the American Constitution by way of a 5th Amendment. And that has become the charter for several democracies in later years to come, to accept that as the foundation for personal liberty. So that was in 1791, the 5th Amendment. Then we had our constitution, our constitutional history in India dates back from 1771, when the first Government of India Act was enacted. Thereafter, there were a series of Government of India Acts, the last one being Government of India Act of 1935, which came into force in 1937. Now, if you compare that, of course, the credit of our draftsmen and the Constituent Assembly is immense, but the major portion of Government of India Act is a part of our Constitution. And the Constituent Assembly was formed in 1946, which was the elected members of provincial and central legislations who were elected in 1946. They formed themselves into Constituent Assembly as well as interim parliament. They started their sessions in 1946, and they concluded their session on 26 November 1949. On that day, the Constitution was signed, adopted. And that's why 26 November is celebrated as a Constitution Day for last 5 years. Before that, it was celebrated as Law Day. The significance of 26 November is because that's the actual day on which the Constitution was signed. But we celebrate Republic Day on 26 January for some historic reason, because on 26 January 1930, at Lahore session of Indian National Congress, the Congress passed a resolution for Purna Swarajya, that is total freedom. And that's why that was the day which is celebrated as Republic Day. So that's our Constitution. Now, What we are going to talk about is the articles from Fundamental Rights chapter, that is part 3, which guarantee to citizens as well as non-citizens certain rights. The rights relating to personal liberty you can find at least in 4 or 5 articles. First is Article 17, Abolition of Untouchability. There is an act also known as Prevention of Atrocities and the Discrimination amongst Scheduled Caste, Scheduled Tribes. There was a Civil Rights Act earlier from 1951. There were penal code provisions, but they were not found adequate. And therefore, this act was enacted in 1989. That's to enforce actually Article 17. Then, of course, we have Article 20, which has 3 distinct rights. The first and foremost is there will be no retrospective criminal law. That's the first. Second is no double jeopardy. That is, no person can be prosecuted and punished for same offense more than once. And third, doctrine against self-incrimination. You cannot be compelled to be witness against yourself or give evidence against yourself. That's what people talk about the 5th Amendment in United States. So that's Article 20. Then the major article, which is Article 21, which is the substance on which we are going to talk about today, is personal liberty. It's one-line article, and what it has become today, I'll discuss a little later. It says, no person shall be deprived of his personal liberty, save according to procedure established by law. I'll tell you about little history of this article also. That's Article 21. Then we have Article 22, which relates to preventive detention, and it guarantees 2 rights. The first is that on arrest, a person must be produced before the magistrate, nearest magistrate, within 24 hours. So his continued detention must be under the judicial authority, and that within 90 days, his case must be referred to an advisory board constituted under Article 22, which has to be headed by a sitting High Court judge. And that board must confirm continuation of that person in preventive detention, because preventive detention, as you know, by name itself suggests, a person is not being detained or arrested for something he has done, but he's being detained so that he should not do something, and that's something serious violation of personal liberty. So it must be with authority of law, and that's why the advice of the advisory board which is constituted under the chairmanship of a sitting High Court judge. So that's Article 22. Then we have Article 23, which prevents the bondage labor or trafficking in human beings. That is prohibited under Article 23. Now you will ask this question, why they are required to be prohibited? But for the simple reason, in United States also, even after the Constitution, for 100 years, after 1776, slavery was legal. People were entitled to buy and trade in slaves. So that was a right, and there was a virtually civil war between southern states and northern states on this right, whether this slavery should be abolished or not. The American Constitution, after its enactment, it took over 100 years to abolish slavery. So we had that article incorporated, Article 23, no traffic in human being, no bonded labor, etc. And Article 24, that's the last in series of these personal liberty articles, that is, children should not be employed at hazardous places below the age of 14. That's a guaranteed right to the children. Then, of course, we have other rights like religion, right to religion under 25, right to preserve and protect your language, script, and culture under Article 29, etc. This is part of Chapter 3, Part 3 of the Fundamental Rights. We also have Part 4, which is Directive Principles of State Policy. But Article 37 proclaims that these principles are not enforceable. In the sense, you cannot go to court and ask that some state is violating this directive principle. You cannot compel that authority to enforce directive principle. But there are several directive principles which now the courts have read into these 4 or 5 articles which I mentioned. And the courts have said, though this right, for example, free legal aid under Article 39A, or living conditions or hygienic conditions at workplaces, no discrimination in employment against women, etc. All these rights which are enumerated in directive principles, the courts have now read those rights in fundamental rights, even though they are part of directive principles of state policy. We'll discuss that. So that's another chapter on directive principles of state policy. Another important article, Article 48A, which says that the state shall take steps to protect environment, ecology, wildlife, and animals and birds and forests. So that's not enforceable per se, but the courts have now read that Article 48A as a part of the personal liberty under Article 21. Now, these are broadly the contours in which the personal liberty issues come up. There are two other important articles which you need to note. One is Article 12, which defines state, concept of state. Now, concept of state generally is the state, union and state executive, union and state legislature, or local authorities like municipal corporations, the planning authorities, etc., public bodies, the public sector corporations, etc., and instrumentalities of state. And there are series of decisions from Ajay Hasia, Ramanna Shetty's case, where the courts have laid down the prepositions how an authority will be considered as a state or not. For example, if an educational institution receives funds from the state government or it is an aided institution, it would be considered for enforcement of fundamental rights. But purely a private person will not be considered as state. But there are certain fundamental rights which can be enforced against a private person also. Like, for example, I told you the untouchability, the child labor, the bonded labor, trafficking in human being, a person, individual, even though he is not a state, also can be subjected to enforcement of those rights. So that's the first concept, that against whom these rights can be enforced. That's Article 12. Then there is another important article, Article 13, which has two injunctions. One is that states shall make no law which abridges or violates rights guaranteed under Part 3, that is the fundamental rights. So the law cannot be made by any legislature which violates any of the fundamental rights under Part 3. And the second important aspect is this Article 13 defines what law is. Law, as we normally understand, is a law passed by the legislature, but that definition of law includes not only the laws passed by the legislatures, that is state legislatures and parliament, but it also includes rules, regulations, bylaws, notifications on customs and usages having force of law. That's the concept of law. So once we know that concept of law, that has very great significance when we come to Article 21, because Article 21 uses the phrase law. So that's the background. And now we go to Article 21, on which we discussed this morning. As I told you earlier, it has one sentence article: no person shall be deprived of his personal liberty save in accordance with procedure established by law. During the Constituent Assembly debates, B.N. Rao, who was the constitutional advisor, he had visited a large number of countries to get inputs from those countries. From American Constitution, the Fifth Amendment, which I told you, which says that no person shall be deprived of his life, liberty, and property without due process of law. So Justice Frankfurter advised him not to have that clause, due process of law. So that was accepted, and the draft constitution actually had this clause that no person shall be deprived of his liberty without due process of law. That was changed, and it was made into no person shall be deprived of his personal liberty without procedure established, save without procedure established by law. There's a great deal of debate in the Constituent Assembly because due process has large number of baggages, in the sense whether that law is valid or not, whether that law has other facets or not, whether that law is otherwise compliant with other directive principles, the fundamental rights or not. So to avoid that, they say that if you want to deprive a person of his liberty, you should make a law, and law should provide that. So that is how the debate proceeded, and they deliberately did not accept the American concept of due process of law and accepted only procedure established by law. That's how the Constitution was enacted. On 26 January 1950, when the Constitution came into being, immediately the first case in 1950 itself was a detention of a journalist called A.K. Gopalan. And there was a petition filed in Madras, then case eventually went to Supreme Court. And that is the first historic judgment on personal liberty. A constitution bench of 5 judges decided that they interpreted Article 21. They referred to the Constituent Assembly debates. They referred to the American constitutional provisions of due process of law and our distinction with procedure established by law. And they held that Article 21 is confined to personal liberty. because American Constitution has three aspects rolled in personal liberty. That is, no person shall be deprived of his life, liberty, and property. So we had all these rights separated in our Constitution. Property right was separated in Article 19(1)(f) and 31, which has full due process. It doesn't have procedure established by law, but it had due process. The due process means your property can be acquired only for public purpose. You must be paid market value for your property. That was the right under 19(1)(f) to begin with. So they said the property has been borrowed, the concept of liberty has been borrowed insofar as property is concerned as per American Constitution, but personal liberty is concerned, it is procedure established by law. So what court will look at is whether there is a law made, whether that law is made by a competent legislature, that is either the state legislature or by a central legislature, and that provides a procedure for a deprivation of personal liberty, and that is good enough. So if a law is made providing that the police commissioner of Mumbai can arrest a person, that is a valid law. He can say procedure is that he can serve a warrant on him, and that procedure need to be followed. So while examining personal liberty, the court will only examine whether there is a law and whether there is a procedure and whether that procedure has been followed. And that is end of personal liberty. Then the question was raised, as I told you, Article 13, that law shall not violate fundamental rights. So would that law require to be satisfying Article 14 or Article 19 test? The court said no. Court said all these articles are watertight compartments. 14 takes care of one right, 19 takes care of another freedoms, as we used to call them. Article 31 takes care of property. Article 25 takes care of right to religion. Article 29 and 30 take care of culture, heritage, etc., or right of minority institutions. So that those rights cannot be brought in when we are talking about personal liberty under Article 21. So that was the restrictive meaning of Article 21 given in 1951. And that needed another 20 years to change that. And that change came about in 1970 in bank nationalization case. That case is R.C. Cooper versus Union of India, popularly known as bank nationalization case. In that case, what happened was 13 banks, private banks were nationalized. And that was challenged in the Supreme Court. In that context, Supreme Court said that all the fundamental rights are compact, they are composite, and they are complementary to each other. They are not mutually exclusive. And second important aspect, therefore, you cannot say that if you are talking about personal liberty, you will not go to Article 19, go to Article 14. But incidentally, of course, that decision rested there. The real liberation of Article 21 came in a celebrated case, which I'm sure you all know, is known as Maneka Gandhi's case in 1978. Now, in 78 or 77, two things happened. There was a new government, as you might know. Congress post-emergency was defeated. There was a government by Janata Party, and they brought in 44th Constitutional Amendment Act. That amendment undid large number of amendments which were done by Congress government from 35th to 42nd Amendment, which were quite non-constitutional or undemocratic, etc., like giving immunity to the candidate who is a prime minister from being subjected to appear in any court, or his election will not be called in question in any court, etc. All those amendments were done away with. They also did away with the right to property. So Article 19(1)(f) and 31 were deleted as fundamental rights, and they were provided in Article 300A as a normal right. So now we had the property rights which had a due process. That is, it cannot be acquired except public purpose. It cannot be acquired except on payment of compensation. Now that right reads that no person shall be deprived of his property save by authority of law. It doesn't say due process. While Article 21 was interpreted by Supreme Court in Maneka Gandhi's case, and they gave full substance to that article, and they laid down 3 or 4 tests. They said all fundamental rights are complementary to each other, and they are not watertight exclusive compartments. 1. 2, law in Article 21 must satisfy test of Article 13. In other words, that law cannot violate other provisions of Part 3, like for example, Article 14 or Article 19. And thirdly, that the procedure also must be fair and reasonable. It cannot be any procedure. That is because they gave new life to Article 14. Article 14 before that was considered as only equality before law and equal protection of law. And Article 14 was interpreted to mean that state can classify persons into classes and then treat those classes differently. As long as two tests are satisfied by that classification, that is, there is a classification done, there is a basis for that classification, and there is a nexus of that classification with the object of classification. As long as these two tests are satisfied, classification would be valid. Maneka Gandhi's case said, Article 14 doesn't stop there. Article 14 hits at arbitrariness. Article 14 hits at unfairness or capriciousness, etc. So therefore, any law which is arbitrary, any action which is arbitrary would be violative of Article 14. So in Article 21, if a law is arbitrary, law is capricious, law does not provide procedure which is fair, reasonable, then that will not be a valid procedure and personal liberty, it cannot be taken away by such a law. That was such a big transformation from the view taken in 1950, in 1978, in Maneka Gandhi's case. Now that since then, from Article 21's liberation in Maneka Gandhi's case, we are in 2022, which is almost 44 years. Now you can read 100 rights in Article 21. So what was confined to personal liberty in the sense of person's physical liberty, in the sense he will not be detained improperly except by procedure established by law. Now Article 21 takes into its sweep almost everything. Justice Bhagwati and Justice Krishna in Maneka Gandhi's case have discussed and said, everything which is required for human being to live with dignity, to have a meaningful right, to have an appropriate life, to have just and fair life, everything what is required in society for that person, in the nation, everything is part of Article 21. That was the huge conceptual interpretation on Article 21, which started in 1978. Now, as I told you about Article 14, that arbitrariness strikes at every action, arbitrariness strikes at every procedure of law. There was a debate whether a law as properly enacted by the legislature, passed by Maharashtra legislature or by central parliament, if that law can be declared as arbitrary. Now, can law be arbitrary and can we strike down the law as arbitrary? That question raised from 1978 till recently. And about 2 years back, in a very celebrated case known as Shaira Bano case, popularly known as Triple Talaq case, the Supreme Court has said a law also can be declared as unconstitutional if it is manifestly arbitrary. And manifestly arbitrary means it is unconceivable that what it has provided is something so harsh, so unconceivable that we will not tolerate it as a valid law. So that's the concept of manifest arbitrariness. And today the law now is, after Shaira Bano's case, that any law can be declared as unconstitutional being arbitrary. Otherwise, the thinking was that arbitrariness is a perspective. I think some act is arbitrary, you may not think so. So arbitrariness was a perspective analysis of a particular aspect. Supreme Court has said law can be declared as arbitrary if it is law can be declared as unconstitutional if it is manifestly arbitrary. So that's a new dimension to Article 14, reiterated and reconfirmed in 2020 in Shaira Bano Triple Talaq case. Now the journey of Article 21 from 1978 till today is so interesting, so interesting. It has taken into its sweep almost everything. Let's talk about first the matters relating to bail and detention. Justice Krishna here in 1978, in another important case known as Sunil Batra case, he declared bail and jail, bail not the jail. That should be the normal concept. So bail should be the norm and jail should be the exception in preventive detention or in normal criminal prosecutions also. That's where that journey began. What are the rights of inmates in the jail? Nobody thought of that person who is arrested either under trial or under the preventive detention has any rights. The court started recognizing his own rights. A person should not be handcuffed as a matter of right. He should not be handcuffed. That should be the norm. A handcuffing should be as a matter of exception. The person is violent, person is likely to run away, while he is being produced in court for remand, etc. No fetters to be put on the prisoners in the jail. No cross fetters like we have seen in those during the freedom struggle at Andaman, how the detainees were kept under bar fetters, cross fetters, etc., so that they cannot have movement, etc. So these are all rights of detainees. No solitary confinement unless there is a special reason. So these are all rights which the Supreme Court started reading in detainees' rights. Now, nobody thought that detainees could have such rights, etc., but the Supreme Court started reading those rights in Article 21. As I told you, Article 21 hasn't been amended. Article 21 remains the same as it was in 1950. In 1978, it is same today, that no person shall be deprived of his personal liberty, save according to procedure established by law. There was yet another important decision, and where that famous judgment of Justice Bhagwati came. A postcard was sent by some activists from Bihar to the Chief Justice of India. And the complaint was, in prisons in Bihar and UP, there are a large number of detainees who are languishing in jail as under trials. What are their offenses may vary from one degree to another degree. What could be the possible sentence they would suffer if they're actually convicted, ranging from 3 years to 7 years or 10 years, etc. And they were in jail as under trials for more than 10 years. The Supreme Court passed an order immediately directing that you cannot be kept as under trial for unreasonably long period of time, and they all were ordered to be released. Now, because that's a right under Article 21, that you cannot be detained for an unreasonably long time, and that comes with another right of speedy trial. A criminal trial must be expeditiously completed because we have the presumption that unless you are proven guilty, you are innocent. So technically, you are an innocent person till you are convicted. So can innocent person be kept in jail for such an unreasonable period of time? Obviously, answer should be no. Where is that right? That right is under Article 21. So that's how the Supreme Court kept on evolving the concepts of personal liberty in cases of bail, detention, etc. There was another facet to Article 21 which was added about the death sentence. Now, procedure established by law, that law provides that in certain cases, death penalty can be imposed upon a person. For example, heinous murder or heinous rape, etc. Death penalty can be imposed. Now, is that a fair procedure under Article 21? So that debate was raised, and the Supreme Court concluded in 1980 in Bachan Singh's case that death sentence per se is not violative of Article 21 as long as the circumstances are considered by the court. The court has discretion to award death sentence in a given case. When will court award death sentence? Court will frame the parameters, and they came out with that concept of rarest of rare case. So that's the concept in which, but death sentence per se is not arbitrary. Death sentence per se is not violative of Article 21 concept of personal liberty. The court will decide in what cases death sentence can be awarded or should not be awarded. So that's the first aspect about death penalty. Then cases came about the precedent under Article 72, a convict of death sentence after the decision of the Supreme Court is final. He can apply for mercy petition, that clemency before the President of India. Now the cases came, can President just keep on sit on that application for years and not decide it? The courts have ruled, Supreme Court has ruled that President must decide that application expeditiously. If that application is not decided expeditiously, that detainee gets the right to get his sentence from death sentence commuted to life. Because that's something arbitrary. You cannot keep a person on hanging death sentence and do not decide his fate for unreasonably long period of time. Recently, you might have read there were 2 ladies from Pune who had killed some 7 other ladies, and they were sentenced to death long back, but their sentence was not executed. And they were waiting for death sentence for almost 8 or 9 years after the Supreme Court decision, after the clemency petition was rejected, challenge to that was rejected, the death sentence was not executed for one or the other reason. Recently, the Bombay High Court commuted their sentence from death sentence to life sentence on the ground that this actually amounts to violation of personal liberty of the person who is on death row. So therefore, that's how the Supreme Court has been reading into the Article 21 personal liberty. Then there are cases about the manner of execution. What should be the manner of execution? In 1950, as I told you in Gopalan's case, Justice Das had said, he was a minority view, that if the procedure established by law is good enough, so you can have a procedure that a person would be sentenced to death by boiling in oil, person would be sent by public hanging, etc. Would that be a valid procedure? He said, as per their interpretation, it was, but now that has changed. There cannot be public hanging, there cannot be execution of any sentence which is cruel, which is inhuman, etc. Now, that's the right which the court has read in Article 21, even of persons who are handcuffed or who are sentenced to death and who are waiting for gallows. Now, that's another facet, bail and sentencing, etc., which the court has read in Article 21. Large number of rights for women have been read into Article 21. Now, you will be, like anybody would get shocked that the Supreme Court had to write a judgment saying that women under trial should be kept in separate cells from the male under trials. Now, that's something anybody would think what was logical, but that was not happening. It was the Supreme Court who had to come to the rescue and declare that women prisoners cannot be kept in the same cell as male prisoners. Women will have the right during the jail also, while they are under trials, etc., for human conditions, hygienic conditions, etc. So all those rights were, or if they have a children, they will be allowed to stay with the children, etc. Sheila Burse's case, etc. Olga. So all those decisions, Supreme Court has recognized the right of women as a part of personal liberty. Right of children are recognized in Article 21 as part of personal liberty. And as I keep on reminding you that this is all same article which was in 1950, which is still in today. And this is all being read by the courts by concept of judicial activism, which is criticized by a lot of people. But that's how Article 21 has evolved over a period of time. There is yet another angle of Article 21, which is very, very crucial, which is in relation to environment and ecology. Article 48A, which was introduced in 1976, says that states shall take steps to protect environment, ecology, wildlife, animals, and forests. Now, Supreme Court has read there are a series of decisions insofar as environment is concerned on three aspects. The first is what is known as coastal regulation zone notification, which of course all of us who live on coastal areas are familiar with. Coastal regulation zone notification takes care of areas between high tide line and 500 meters in which no destructive activities should be carried out so that the coastal zones are protected. And that applies from Gujarat down right up to Calcutta on the coastal line. So there is a notification called CRZ notification of 1991 that was not being implemented, and therefore the Supreme Court had to step in. And there are at least 25 decisions which are titled the same way, MC Mehta versus Union of India. MC Mehta is a lawyer activist in Delhi who has kept on filing the petitions for enforcement of CRZ notification. So you will find about 20 decisions of Supreme Court in that name, which are for enforcement of the CRZ notification. The courts have said that the ecology, this environment is a part of our society. Unless we preserve ecology, environment, flora, fauna, forest, wildlife, etc., we are not going to have meaningful life. The preservation of nature is also part of our right of personal liberty, and therefore it must be protected, and it is the duty of the state to take steps for protection of that. So you can go and complain that a CRZ notification is not being followed, there is a damage on the coast, etc., and that would be considered as citizens' right under Article 21. So that's one aspect of CRZ notification as a part of environment. Before that, of course, I should have told you that in 1986, for implementation of the 1972 protocol, which was signed by the United Nations, all members, including India, Environment Protection Act was passed for enforcement of the or protection of environment. Before that, there were two other acts known as Air Pollution Act and Water Pollution Act, which are primarily applicable to the industries. In the sense, if you want to set up an industry, you need to take permission from Pollution Control Board under the Air Act and the Water Act, so that you operate your industry in such a manner that you do not pollute the rivers, pollute the environment, etc. And those norms are prescribed under Air Act and Water Act. Now we have three laws relating to the enforcement of the environment: Environment Protection Act, Air Act, and Water Act. there was yet another act called Forest Conservation Act of 1980, which says that no forest area shall be converted into non-forest area without prior permission of the central government. And the central government will grant those permissions on the condition that you will do the afforestation, social afforestation. For example, if you cut 100 trees, you must plant 400 trees and do the social afforestation. So those are the conditions, etc. So that act was also not being implemented, and Supreme Court had to step in. And you will find another 20 decisions in the name of T.N. Godavarman versus Union of India. All directions given to states and Union of India for enforcement of the Forest Conservation Act for protection of forests. So we have the protection of coastal zones, we have protection of the forest areas. Then there is a notification called Environment Impact Assessment Notification. So if you want to carry out any activity which is enumerated in that notification, you need prior environmental clearance. For example, if you want to set up a hydropower project or a chemical plant or even housing colonies in excess of 20,000 square meters, you need environmental clearance. Now that's a part of your personal liberty. They become enforceable right of the citizens that this industry does not have environmental clearance. This industry does not follow air pollution norms or water pollution norms. Rivers are being polluted, etc. So all that is now part of personal liberty under Article 21. Then there are other issues relating to wildlife and forests. Wildlife Act requires or empowers the government to declare what is known as reserved forest, wildlife sanctuaries, and the other sanctuaries. Like, for example, recently, this Thane Creek has been declared as Thane Flamingo Bird Sanctuary. There is a sanctuary, National Park is a sanctuary. Then there is another sanctuary at Tungareshwar. So there are about half a dozen sanctuaries in Maharashtra. Now they were not being declared. The Supreme Court again had to step in to say that this right, the declaration of these sanctuaries, etc., is a right under Article 21 of all citizens in the state, in the country, and therefore those steps must be taken expeditiously. And otherwise, Supreme Court threatened that if you do not, then we will impose restriction on activities being carried out within 10 kilometers of the proposed national parks, wildlife sanctuaries, etc. And then all states finally proceeded to declare their sanctuaries, etc. So that's yet another right which is read by Supreme Court in Article 21 about environment, ecology, etc. Now that keeps on going. For example, in Mumbai, the Supreme Court has read, like, we have buildings constructed in Mumbai under the provisions of Mumbai Municipal Corporation Act, Town Planning Act, and Development Control Regulations. And we have something called concept of open spaces. Open space, like on a plot of whatever plot, you need to keep open spaces from your boundary to the building so that the fire engines can move. You have enough space for that. So the corporation used to sanction relaxation of those conditions, because otherwise the builders could not carry out construction of adequate quantity. The Supreme Court in Kohinoor decision, Kohinoor judgment, Supreme Court said that open space in the building is a part of your personal liberty. So the corporation as a planning authority cannot sanction plans which deprive the probable occupants of that building. You are not even an occupant of that building. You will buy a flat or an office in that building, but you have right to have open space in that building. Then there are mandatory open spaces, recreation spaces, and open spaces required on a plot of land. So the builders used to provide that on the podium or on the top level. The Supreme Court said, no, that green space must be at the ground level, open to sky on the ground level. Otherwise, you will have seen in several buildings podium gardens, which were substituted for the garden and open spaces. Supreme Court said, no, that is not permissible. You can provide additional podium gardens, but the open spaces on the ground level must be there as a part of your personal liberty. Now, that is what Supreme Court has been reading into Article 21. In last year, you must have read about two building crashes. One was at Bhiwandi and another one at Malwani, the slums in Mumbai. Now, those buildings collapsed because they were not constructed of engineering standards. And the municipal authorities, both in Bhiwandi and Mumbai, have sanctioned the plans without appropriate and without due care. The Bombay High Court last week delivered a judgment on that and said that proper planning, conditions, and ensuring that the building which is constructed is safe from engineering point of view, fire safety point of view, is a part of citizens' right under Article 21. So that's what the Supreme Court has read into Article 21. And that list goes on. Then we have other aspects like legal aid, free legal aid. There is a separate article under Article 39A, which says that states shall ensure that free legal aid is provided in criminal trials. Now, on that, the Supreme Court has delivered large number of judgments. Generally, what happens is there is a panel of lawyers made for free legal aid to this in criminal matters. Those lawyers do not read the cases, they go to court, appear, and then, so the courts have come down heavily on that, saying that legal aid, free legal aid must be meaningful. It is not a lip service to Article 39A. And if the detainee does not get appropriate legal aid, it is his violation of Article 21 right. So detainee's right under Article 21 includes free legal aid also. The free legal aid must be meaningful. Free legal aid must be effective, otherwise it is not valid. Then on conviction, the person must get a copy of the judgment also immediately so that he can take the steps for appeal, etc. For that also legal aid must be provided, otherwise there is a violation of his liberty under Article 21. So these are all various facets which are being read in Article 21. Now recently, there was an issue which arose from Delhi High Court about validity of Section 377 of Penal Code about transgender equality, or what is popularly known as homosexuality, which was an offense. Delhi High Court struck it down, holding that this is discriminatory, this is arbitrary, and therefore violative of Article 21 of the Constitution. Now, this 377 was an old provision, pre-constitutional provision, because Indian Penal Code is of 19th century vintage. There is a provision in Article 13 again that a law, existing law in force on 26 January 1950 shall cease to be a valid law if it violates of the rights guaranteed under Part 3. So that on that basis, Section 377 of Penal Code was declared by the High Court of Delhi as unconstitutional, and what is popularly called by activists, they decriminalized homosexuality. That judgment was finally decided by the Supreme Court in common cause in 2020, and Supreme Court has accepted that. Supreme Court has declared that as violative of Article 21. So that's where we have reached from 1950 till 2020. There are two other important decisions I must make a reference to. Now we are in the age of telecommunications. So the courts have held that the means of telecommunications, including telephones, telecom, and of course the internet, is like now a part of your personal liberty, because your life now depends on that. It's like earlier there was food, shelter, and clothing. Now in that you need to add internet. So that these are the four rights of human being. So Supreme Court has virtually accepted that as a part of personal liberty. Now who provides that, etc., is a separate issue, but that's a access to that, availability of that is the right of personal liberty. In that, you have social media, you communicate freely. Now, can state interfere in that? Can state intercept those messages? Can state take action on that? Can state interfere with that, etc.? All those questions were raised in a celebrated decision known as Shreya Singh's case. Shreya Singh was also incidentally a law student like you, and she had filed this petition in Supreme Court. And Supreme Court declared Section 66A of Information Technology Act as unconstitutional, primarily on the ground that it authorizes state to interfere in your private communications, which is not permissible, which is a clear violation of Article 21A. Now, this is generally about, now the last judgment I would refer to, which is one of the most important judgments, which has now widened these horizons of privacy, a public right to personal liberty, etc., is Puttaswamy's case in 2017. It's a nine-judge bench judgment, and that has accepted what is known as right to privacy is a part of personal liberty under Article 21. So you can manage your affairs in such a way that there will be no interference from the state in any manner. And that's the concept of privacy. Privacy is that you lead your own life. You lead your own life the way you want, and there will be no interference. Now that brings the question, which popularly known as is being debated today, right of choice. What I do, what I wear, what I eat, They are all part of my right of choice, right of privacy under Article 21. Now, this was something unimaginable in 1950, personal liberty. Does it say all this? It doesn't say that, but the courts have read into it. Right of choice, what I eat, what I wear, what I do, who are my friends, where I go, right to travel abroad, right to travel in India, all this is part of personal liberty. That is the expanded horizon of right of personal liberty under Article 21. And that is being kept on expand, that is going on expanding with the new decisions. So this right to privacy judgment, it's a 9-judgment judgment in Puttaswamy's case. Of course, it's popularly known as Aadhaar case, because the issue of whether Aadhaar card is valid, whether you are compelled to submit your Aadhaar card for with your permanent account number, with your bank details, etc. The court have held that to be voluntary, because otherwise it will violate your personal liberty. But if you want to draw the benefits from the government, like the subsidies, etc., then in that case, government can say that your Aadhaar must be linked. So to that extent, it is permissible, but otherwise it is not mandatory, it is optional. Now, there are other 2 decisions where a person can be subjected to lie detector test in a criminal investigation. The Supreme Court has said, no, that's violates your Article 21. Can you subject it to be DNA test, whether you should be mandated or you should be compelled to give your DNA for examination? Now, in one of the cases, where the issue in a matrimonial matter was about the parentage of a child, the Supreme Court said, the trial court passed an order that the DNA should be tested. So whether the child belongs to that couple or not could be established. That Supreme Court said you cannot compel unless they're voluntarily giving it. That would violate your personal liberty. So forcing somebody to subject himself or herself to DNA test would violate your Article 21 right. Now, how to solve this question? The Supreme Court said Normal Evidence Act provisions are there. If somebody is doubting the parentage of that child, you can establish that as per normal procedure in a court of law, but not compelling somebody to, because that will not only violate Article 21, but will also violate Article 20, that you are compelled to give evidence against yourself. So these are the various facets which have been made into Article 21 or Article 20 in some cases, etc. And as I told you, it encompasses almost every sphere of our activity. It encompasses every walk of our life. There is nothing which has escaped Article 21. You walk on the road, you are entitled for good roads. You are entitled for a planned town plan city. You are entitled for good non-polluted air. You are entitled for good potable drinking water. You are entitled to have non-polluted rivers. You are entitled to have a proper ecosystem where birds, wetlands, etc. are properly maintained. You are entitled to have the forests maintained. You are entitled to have pollution-free air, non-polluting industries, non-polluting activities. All this is, I am again saying, nothing is written in Article 21, but everything is read into Article 21. And the object is that for a meaningful human life, whatever is required is part of Article 21. That's the underline of Article 21. And I can say and conclude saying that as long as humanity lives, as long as society lives, the last word on Article 21, what it encompasses, is never said. And it will always be evolving, and it has evolved in the last 40 years. It will continue to evolve. And when you start practice, when some of you become judges, etc., you will have that opportunity to make further exponential interpretation of Article 21. And as I said, whatever is required for humanity, society to make life better is part of personal liberty. Thank you.
So it is truly an honor to listen to you. In fact, I'm sure when we leave this classroom, we will all have a better understanding of personal liberty, I'm sure. Okay, with this, I open the session to questions and answers. Any questions? Yes.
Sir, you had referred to various articles are complementary and not watertight ones and otherwise earlier. Can you just please explain on this aspect?
As I told you, in 1951, when they interpreted Article 21, which says that procedure established by law, whether that law should be compliant with Article 14 or Article 19, court said no, it is not. So in 1950, court said they are not complementary. Post 1978, law must satisfy Article 14, that it should not be arbitrary. The procedure should be fair. Procedure should be just. That was not open prior to 1978. So today, a law under Article 21 must satisfy all other tests also, which was not required prior to 78.
So I have two questions. One is, if you can throw some light on when you mentioned that in first declaration of US Constitution, it was declared that all men are born free. But then you also mentioned it took 100 years to say that, to end the slavery. So why it took 100 years when it was first mentioned that all men are born free?
See, making a declaration in Declaration of Independence in 1776, that was the object. Like that declaration is like preamble of our constitution. That is an ideal utopian situation. When they made the constitution, actually from 1776 to 1787, that right was not recognized in constitution. All men are born free, they are equal, etc. was not actually accepted in the constitution. They added it by way of personal liberty by way of Fifth Amendment in 1791. Despite that, slavery continued because that had to be enforced. And see, making a law is one thing, enforcing that law is another thing. That took 100 years. Till Abraham Lincoln became president in 1860. Till then, the slavery continued from 1791, despite there being a written constitution.
He was murdered also for that reason,
Sir, and the other question, you also mentioned about wildlife and forest. Where wildlife sanctuaries are declared as, right to liberty. So again, referring to the case, there was a case where the construction of metro was halted due to RA forest. So is RA forest considered as sanctuary, and that's the reason?
No, I told you, this is not sanctuary. This is a forest conservation. There is a Forest Conservation Act of 1980, which says that any land which is forest, and they are declared forest. So forest has been, from 1975, everything which is forest is declared as a forest. So if you want to carry out non-forest activity in forest, you need permission of central government. And central government grants that permission on the basis of public interest by conditions that you need to cut the forest. So you must cut the forest. But the condition is that you will do equal amount of social afforestation. For example, if you cut 100 trees, you must plant 10,000 trees and take care of them for 10 years. And all that money has to be paid by the project proponent. Project proponent has to find a land where these trees will be planted. He has to take care of those plants for next 10 years. So that's a condition. So that's the so it's not a reserved forest, but it's a forest, not a sanctuary, but a forest.
Students from Nari Gulsani College, I think Harsh Mulchandani is raising his hand. Would you like to ask something?
Hello, am I audible? Hello, sir. This is Harsh Mulchandani here. I am a student in FY LLB. And, sir, I have a few questions. And the first one among them is, the courts cannot compel a person to go for DNA fingerprinting or go for low detection. But the police officer during investigation compels the accused to hide blood, semen, etc. samples. Is it not violative of accused person's fundamental rights?
There are two things. One is fingerprints, etc., is for identification of a person. It is not used as evidence, but so the police can take that. That's not violative of Article 21 because that is used for the purposes of establishing identity of a person. But if that is being used as an evidence to convict him, that will not be permissible.
And sir, what about high blood semen samples, etc.?
That is also for identification of the person and connecting him to the evidence, but that will be subject to cross-examination.
Okay, sir. And sir, I have one more doubt. Should I ask now?
Yes, please go ahead.
Sir,
Go ahead.
How to challenge a law which is added in the 9th schedule of the Constitution?
See, 9th schedule has to be read with Article 31B. which was introduced by the first amendment in 1950 itself. Like, it's something ironic that we started Constitution on 26 January, and in June we had the first amendment by which Article 31A and 31B were introduced. 31B says any law which is in the 9th schedule cannot be questioned on the ground that it violates Article 14, 19, or 31. That was first interpreted in Vaman Rao's case in 1980, and it said that if the law is in 9th schedule, you cannot question that on the ground of 14, 19, or 31. But that was reviewed, and that's the case I think Madam referred to, which I appeared. That was Ayer Coelho's case in 2007, in which this law was looked up, was relooked. And the Supreme Court, by unanimous judgment of 9 judges, Chief Justice Sabarwa's judgment, they have said that you cannot challenge that law as violating of Article 14, 19, or 31 because it is in the 9th schedule. But what you can do is the constitutional amendment by which that law is put in the 9th schedule, that constitutional amendment you can challenge by applying the Keshwanand Bharati principle of basic structure. You say that this law is put in the 9th schedule, that damages the basic structure of the Constitution. And how do you find out? Because the constitutional amendment only says following laws are inserted in the 9th schedule. So that law doesn't have any substance. So therefore you go and look at the substance of the law, which is the subject matter in the 9th schedule. So for example, if there is a law which says that your property will be acquired if a minister desires to have that property. Now that law is put in the 9th schedule. So you cannot challenge it on the ground that it violates 14. But what you can do is you challenge the constitutional amendment by which this law is put, and you can say the right to equality, which is a basic structure, is violated by putting this law in the 9th schedule. That's how you can challenge that law.
Okay, sir. So basically, any amendment in the Constitution cannot challenge the fundamental rights.
No. If you want to challenge the law, you need to challenge the constitutional amendment inserting that law in the 9th schedule on the ground that it damages the basic structure.
Okay, sir. Okay. Sir, I have a few more doubts. Should I ask that now?
No, let someone else get a chance to ask something. Please, Harsh.
Yeah, ma'am. Thank you so much.
We have Veena Banerjee.
Okay.
Thanks, sir. Sir, I have a question whether principles of natural justice are enshrined in Indian Constitution.
They are very much enshrined as a part of Article 14, because Article 14 says, as I explained earlier, it also there is a one-line article which did not have various facets which are read into it. Article 14 says, no person shall be denied equality before law and equal protection of law. That's all that it says. And earlier it was interpreted to mean that a classification. But post Maneka Gandhi, they have said any action which is arbitrary, unreasonable, unfair, capricious, whimsical, they all will be violative of Article 14. So if you do something, take an action which is in violation of natural justice. What does natural justice require? Natural justice requires you to give an opportunity and hearing so that you know what is being decided against you. That these are the two basic, and the person should not be biased who is deciding. So if that is not done, it is a clear violation of Article 14.
Okay, sir, one more question I have. Sir, as you said that we have right to liberty, like we have right of having clean environment now. So nowadays we are seeing that because of the construction more going on, all agricultural lands are getting converted into NA plot, and for that permission is being taken, sir. So it is ultimately going to affect somehow in the coming years, not for our generation, but the coming generation, it is going to affect the environment as well as whatever we are having the resources. So how can we go about it? Like,
see, this has been discussed by Supreme Court in a case known as Kamal Nath's case, which is you need industries because we have large population who must be sustained with industrial activities as well as food production. So what the Supreme Court has said are three things. One is that there should be a sustainable development. That is, you have to strike a balance between your needs today. You cannot say that we need to, the agricultural land would be destroyed, agricultural land would be converted into non-agricultural land. If it is required and reasonably required, the court will accept that as a matter of sustainable development. That is one. Second is the principle which our Supreme Court has said that if it is wrongly done, then the polluter pays. And the third is that we have to preserve this forest, wildlife, etc., for our succeeding generations, because it's not only our. So these three principles are considered. Any action, if you challenge that this large tract of agricultural land converted into non-agriculture, etc., the court will consider that on the basis of balancing the sustainable development, the rights rights violated, as well as the necessity of the society.
Okay, sir. Thank you, sir.
Thank you. Now I invite Assistant Professor Bhanu Advani to give away the vote flags.
You have a question? Brief?
Yeah.
Can we take it? Okay.
What is the most important habit or a thing we as law students can inculcate in ourselves over time?
Wow.
You know, in Constitution, there is a answer to that article. I'll read out to you. There is also a chapter on fundamental duties. Article 4.
51, no? What
Yeah,
what is 51?
To develop the scientific temper, humanism, and the spirit of inquiry and reform. That's the answer to your question.
So once a great man said, feeling gratitude and not expressing it is like wrapping a present and not giving it. On behalf of the DMHSL School of Law and all the students, I would like to thank our esteemed guest speaker, Dr. MILIND SATHE sir, for taking his precious time out and enlightening us. I thank our respected director, Dr. Nilima Chandiramani madam, for organizing this seminar. We have been fortunate enough to be backed by Honorable Vice Chancellor Dr. Hemlata Bagla ma'am. She has been a source of constant support and gave us a lot of encouragement. Thank you, ma'am. Thanks are due to Assistant Professor Riddhima Singh for anchoring the seminar, to Registrar Dr. Bhagwan Balani and Assistant Registrar Mr. Manish Karale for their kind support, to Assistant Professor Sachin Pimple for maintaining the record of this event, to Assistant Professor Krishna Kamath Keskar for introducing our guest speaker. I thank Assistant Professor Bhanu Advani, who is me,
Yes.
painstakingly preparing the brochures, organizing the program, informing the students, and for capturing the photos. I extend my sincere thanks to Ram Verma and Ajit Surve for their technical support. At last, I thank all my dear students for showing their interest and for making this program a huge success. Thank you. I request everyone to please stand up for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you.
Thank you so much.